Hello, everyone. I'm going to take this time to just explain a couple things on behalf of the board president and the superintendent. We are waiting for our other two board members. And understand we don't have to start at 1 o'clock. We just cannot start before 1 o'clock. So we're still okay. And the public comment everyone was concerned about, you will be getting public comment opportunity in each item. Special board meetings are a little different. You have to provide it before or during the item. We elected to, the three of us elected, it was probably wise not to do public comment before the interviews, basically because if public comment goes 3 hours again or 2 hours, we would have attorneys that we want to interview really on hold. And that's not fair to them and their time. So we will be giving you public comment for sure on both those items. All right? Another note, Superintendent Henson asked me to explain that if you are a member of the public or the media or I guess there wouldn't be any other capacity right now, outside of school employees, if you do see district employees here in the room attending this meeting during their workday, they have taken personal time to do so, or they have been required to attend and bring their services to the meeting that we need for support. So please don't think that we're letting people come on paid company time to sit in a board meeting, because they're not.
Well, that's one way to take care of it.
Not anymore.
Happy Friday.
Appreciate your question. I would direct any tech questions to the gentleman back there.
Sorry, late getting off the hill, my fault. Gentlemen, sorry. Thank you very much.
Just do some more housekeeping over here. Just so you know these.
Specific question to
I don't know. We just can't start here the next interview before their scheduled time, but we can go over it. We're not there yet. And Tracy let us know that she may
answered our questions. We're going to ask you to explain specific issues.
Welcome, everybody. This is a call to order. We're going to begin with a vote
Time,
all the time.
107.
7 o'clock.
I got it. 107.
107. We'll call to order. We're going to have a roll call first. Cheryl Clifford, present. Mr. Haynes.
Here.
Mrs. Haynes. Here. Phil Lewis.
Yes.
Mr. Wallace.
Yes, I'm here.
Mr. Henson.
Here.
Secretary. Our student persons are here today.
Our student board member wanted to attend, but he wanted me to let the board know that he is currently from 1 o'clock to 3 o'clock at a scholarship meeting interview at Simpson University.
Okay, we'll have the flag salute.
Salute. Pledge.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The next item is approval of open session agenda as presented. All in favor, say aye.
Take a motion.
Make a motion to approve.
Gail.
Motion to approve.
A second.
It's been approved and seconded. Any discussion? Let's vote to accept. Aye.
Aye.
Aye. Aye. Yes.
Unanimous approval. Okay. New business, interviews of professional legal counsel services providers. And we're going to hear first from the law firm Atkinson, Hendelson, Lawyer, Rude, and Roma. I'm going to turn this over to Steve to introduce these people.
Yeah, according to the board agenda, we can't start the interview until 1:15 because it's set. It's basically set within the agenda, so we do have to wait until 1:15. At this time, when we begin, I will be asking interview questions. Basically, in the best hiring practice and fair hiring practice, we'll ask all the candidates the same questions. Follow-up questions can be asked based on the individual candidate's answers. So sometimes you might see that there's the same question, but one of the trustees may have a follow-up question somewhere in that area. I have added a last interview question that is not on your sheets, but I will ask it. And basically, the last interview question states, does any trustee have any specific questions to the firm or attorney in regards to their contract? Because that's specific to that contract.
Would you please repeat that?
I'll be asking the question if any of the trustees have any specific questions for any of the legal firms or the attorney in regards to the individual contracts that were submitted. I think in the interest of public comments, or Madam President, I recommend that you don't ask for public comments until after all three have been interviewed.
I had no plans to do anything differently.
Thank you. We have 4 minutes.
Is there a place? I don't see a place for.
I explained that just to let, you might have been out of the room, that it's going to be during the items. So after the interviews are done, we'll call for public comment, and then after we present the motion, there'll be discussion and public comment before they vote.
Are you planning to stick to the 20-minute rule? 20 minutes at
That is
home.
completely your decision. I am not a decision maker in this room. I'm a note taker.
Well, after the Brown Act class I took, I'm gonna take their advice and confine it to 20 minutes, and each person has about 3 minutes.
Our board doc policy does support that you can change, you can allow for longer if you would like to.
Not today.
Okay, so the decision of the president is to limit public comment on each item to 20 minutes.
Not the comment period.
Right.
But each person gets 3 minutes.
Each person gets 3 minutes, which is standard, but then you're stating that the total combined time for public comment for each item would be 20 minutes. So 20 minutes for the first item and 20 minutes for the second item. I'm clarifying. Because you have to allow public comment for each item.
How many items do we have?
2. We have the interviews, which is 1 item,
Oh,
and then the action is the second item.
So they can have public comment on this item, they can also, once that's closed. No, you have interview. This is 1 item, actually, public comment here, and now you're gonna go to the next item, which is 5B, and you can have public comment. You have to have public comment here.
There are 2 different items.
Same topic, they're 2 different one is the action of interviewing and listening to what they're gonna be saying, and then the other is if you're gonna take action. So, yeah, it's written in 2 different.
Can I ask whether you want any input from the other board members with regard to the 20 minute? I was wondering if you could ask the other board members for any input with regard to the 20-minute limit. I mean, you have a board of 5 members.
President's choice, Cassetti.
I understand it's her choice.
Good.
That's not what I'm asking.
the answer is no, I'm not gonna do that.
Thank you.
Madam President, it's 1:15.
So is our first candidate available?
We're working on bringing them up to the screen.
John, can you hear us?
I can hear you.
Can you see us?
I can see you up above my screen. I mostly see myself.
Yeah. So, my name is Steve Henson. I am the interim superintendent. And I have with us all the board members, the president. I'm going to have them introduce themselves.
Carol Clifford, President.
Lindsay Haynes, Vice President.
Elias Haynes, regular board.
Dale Wallace, member.
Phil Lewis, member.
So we have a series of questions that we'd like to ask you, and we'll be asking these same questions to the other 2 candidates that we're trying to look at hiring legal counsel. Don't hesitate to ask for clarification or for me to repeat the questions if you need it. With that, we, just like you, we're probably limited on some time, so if you can keep some of the answers short and concise, but please don't leave something out that you think is important for us. Is that
Well,
okay?
it's usually difficult to answer short answers for a lawyer.
Okay. I'll just ask you, start off with who do you represent and which firm?
Okay, I'm with Atkinson, Allison, Lawyer, Root, and Romo. My name's John Dietrich. I'm one of the partners. I've been with the firm about 25 years.
Okay, thank you. So the first thing I'm going to ask is, does your firm currently contract with school districts or have you in the past?
Could you repeat the last part?
I'll repeat the whole thing. Does your firm currently contract with school districts, or have you contracted with school districts in the past, if you haven't now?
Oh, yes, we do. We represent about half of the school districts in the state of California.
Okay. And can you please provide a synopsis of your firm?
We have about 250 lawyers. We have 10 offices across the state. And about 2/3 of our lawyers represent school districts, colleges, special districts, cities, and counties. And the other 1/3 of the firm is sort of traditional with an emphasis on labor and employment.
One thing I forgot to say is that after each question, if the trustees, president, if you have any follow-up questions, we'll just stop you from moving forward. You can ask a follow-up question on that particular item. If there are none, next question is, how many collective bargaining agreements with school district unions have you negotiated?
Me,
You
personally, oh my gosh, hard to count. I've been negotiating pretty much ever since the Great Recession, and used to work in Southern California, but moved my practice to Northern California. I'd say, gosh, individual collective bargaining agreements, certainly well over 100.
So, the second part of that question is, of those, and you may not be able to come up with specific answers to this, but of those, how many have gone into impasse and or PERB, and what was the outcome?
Okay, so I've been to impasse a number of times, probably 20, 25, and we've resolved every one of them at one stage of the impasse or not, or another. Probably we had to go to fact finding about 5 times, but we never got past fact finding. We always settled each one of those contracts. Going to PERB, that's a pretty common event as well. The labor unions tend to view unfair practice charges as a way to get leverage in difficult negotiations. And, of those, so I've probably had at least 30 or 40 unfairs. Of those, only 5 have gone to hearing, and we've done pretty well in the hearing process. But you have to understand that PERB is a very employee-oriented and employee-friendly place. So it's difficult for employers, school districts, to get a fair shake when you're before PERB.
Thank you. What experience have you had dealing with union grievances and employee discipline issues?
Oh, my goodness. I've dealt with hundreds of grievances. I've probably personally been to arbitration over grievances, over 30 times, probably perhaps more than that. And of the grievances that went to arbitration, I've got a pretty good won-loss record. I think we've won almost all of them, and we lost 2.
How many uniform complaints and Title IX complaints have you investigated, and what is your process to ensure that you and the district meet the timelines associated with these complaints?
Okay, well, this is an interesting question because I do mostly labor and employment work, and I also do real property acquisition and environmental work. I really don't investigate complaints. What we have in our firm is we have an investigation team that is set up that investigate complaints, investigate Title IX complaints and issues. And my goodness, over the last 5 years, the team has grown, and every one of the attorneys on that team are very, very busy.
Sure.
On the Title IX work that you've done, Title IX has kind of changed since it was originally written, hasn't it? So that it includes
Yes,
a
it
lot
has.
more
My understanding,
things.
again, I'm not really a Title IX expert, but it has changed. There was Title IX, and then Title IX was revised under the Trump administration, And now Title IX is being revised again under the Biden administration.
So,
And essentially, in a nutshell, as I understand it, Title IX started out primarily being geared towards women getting equal opportunities in sports and things of that nature, but it really morphed and became much bigger than that. And then beyond that, the rules were changed under the Trump administration to give respondents to complaints more equal rights. And then again, they're being revised by the Biden administration to basically roll back some of the issues that were contained with, or were revised by the Trump administration.
so the laws are pretty fluid there, and no wonder you have to have more people working on it.
Well, yes, and the number of Title IX complaints that have come in over different topics other than athletics have grown too.
Thank you.
What is your experience in interpreting ed code in support of district requirements and needs?
That's probably a daily thing. I'm very familiar with the ed code. I do advice and counsel calls, virtually every day. And if I'm out negotiating in the field with a district, usually things come up throughout the day that we work through. So I'm very familiar with the ed code and assisting clients with that.
This next question, I think that you've touched on it already, but I'll still ask. Aside from the legal research databases, what resources do you have readily available should you be tasked with an area of law that you are unfamiliar with?
Well, that's the beauty of our firm, right? We have 250 lawyers practicing in all areas, and we have specialists that work in individual areas of law. While I do a lot of different things, i.e., I do school district work, community college work, and labor and employment, as I said, and real property and environmental. We have specialists in all those fields. So when an area of law comes up, it would be our practice to go ahead and get our expert in touch with the client in order to make sure that the most expedient answer can be reached. And many times the experts will already have dealt with that issue and are very familiar with it. There's two areas of law that I really don't touch, and that's special education, though I'm somewhat fluent in the lingo, and bond work. But we have a special education department made up of about 30 lawyers, and they are also very, very busy. And we have people who also do bond work, but they're located in Southern California.
So, Gateway currently has 244 active employees and approximately 2,200 student enrollment. Frequently, we have multiple student, employee, or public issues arising on any given day. How will you prioritize dealing with the issues, and what will you do when you have multiple issues that require immediate attention?
Well, one of the things another strength of our firm is that we have a lot of bench strength. So if we have multiple issues needing immediate attention, I'm going to get other team members involved. And depending on the nature of the issue, I'm going to draw upon the expertise within the firm in order to make those assignments. I mean, one of the things which I prioritize in my practice is when I intake a matter with a client, I try to find out when does it need to be completed by so that we can go ahead and have deadlines established and meet our deadlines. Nothing drives me crazier than missed deadlines.
Thank you. How does your firm support school districts in remaining informed with changes in the law?
Oh, that's okay. So we have a number of publications which we put out. We do client alerts on changes in the law, and we send those alerts regularly to our clients. I think there's sample information and materials that I provided with regard to that. But in addition to that, we do workshops and seminars. In Southern California, we have a group known as the Inland Personnel Council, and the Inland Personnel Council has about 72 members, and the IPC, as it's called, ends up putting on regular workshops and then does a 3-day retreat each year annually. And all of that is to keep clients apprised of the changes in law and the hot issues of the day.
My apologies to the trustees, I skipped one of the questions. I'll go back to it. What experience do you have regarding employee leaves, Ed Code, FIMLAW, CFRA in conjunction with bargaining unit agreements?
Well, it's a regular issue which comes up, right? Even last week, we were negotiating over bereavement leave in a district up in Northern California. And the law had changed on bereavement a bit since our contract was in place. So that's a regular thing that comes up in almost all negotiation cycles.
So what experience do you have in dealing with the maintenance and operations side of the school district when looking at the following public bidding contracts and the regulations set forth regarding them, CUPCA accounting practices, labor law related to classified staff, state and federal law related to district facilities, and required practices, procedures to be followed?
Okay, I'm a little bit of an odd duck within our firm because I do practice on facilities matters. So I'm somewhat familiar with those issues, but with respect to public bidding, CUPCA, and things of that nature, that's something where I would rely upon our facilities practice group in order to assist me with that because we have people who specialize in those particular areas of law.
Okay. Next, Gateway has the largest bus area in Shasta County, and our transportation department is crucial to getting students to our schools on a daily basis. What experience do you have in dealing with the transportation side of the school district and the required state and federal laws binding them?
Well, a number of issues have come up in transportation within my practice. I've had to deal with bus driver student issues, cameras in buses, safety issues. I dealt with a dispute between the South Coast Air Quality Management District and a school district over bus procurement because of the fact that in Southern California, diesel buses are extremely disfavored, and what they want are natural gas buses, so I'm familiar with that. And if there's any particular area that I'm not familiar with, we've got an expert who I can pass the work to.
Are you aware of, or do you foresee any conflict of interest in representing Gateway Unified School District?
No, I don't think so. We did a conflict check before we even sent over a legal services agreement to make sure we wouldn't have any conflicts in intaking a new client, and it came up without any conflicts at all. In addition, up in the Reading area, we don't represent many school districts. We represent the college, Shasta College, but I'm not aware of other school districts in the Reading area. We go about as far north currently as Red Bluff, where we represent the county superintendent and several school districts in the Red Bluff area and Corning area.
Okay. So at this time, I'm going to ask if any trustee has any specific questions in regards to the contract that was submitted by Atkinson, Allison, Loya, Rude, and Roma.
Yeah, Member Clifford here. I'd like to turn your attention to number F, services performed by law firm provided non-legal consultants.
Yes.
Okay. It says the law firm has an affiliation with non-legal consultants who are available to provide services in areas including but not limited to, and then it has a pretty long list. And then the next paragraph says, because the law firm has a financial interest in the district's use of these affiliated non-legal consultants, the rules of the State Bar of California require that the district provide its informed written consent to this arrangement prior to utilizing these services. The execution of this agreement will be deemed informed consent. For the purpose of this paragraph, the district is hereby advised that it may seek the advice of an independent attorney of your choice prior to providing such written consent. And then farther down, it says that please be advised that the services of these non-legal consultants are provided to the district outside of this attorney-client relationship. Communications with these non-legal consultants will not be protected from disclosure by attorney-client privilege. So I'm wondering, does that mean I should be consulting another attorney before I agree to this? What happens if we don't go along with this? How does our coverage change?
Well, okay, so the non-legal consultants are from a group called Education Support Services, ESS, and it's generally made up of experienced education professionals who've retired. A lot of former superintendents, and what they provide is real-life expertise, not necessarily legal advice. And they're only provided on an as-needed basis, and you don't even need to actually use the services of ESS unless you want to. Many clients find that those professionals provide expertise which is useful because they've seen the real world issues. And the reason that language is in there is because our general counsel wants to make sure that our legal services agreement is in full compliance with all bar regulations and rules of the state bar.
So we shouldn't be concerned if if you recommend somebody that is non-legal consultant, that we're gonna lose any of our defense attorney-client?
No, and one of the things we do is we try to keep the legal issues stay with the lawyers, and
But not with the
non-legal
non-legal
people,
consultant.
they don't give legal advice. And so if you are working with a lawyer, the attorney-client privilege applies to all communications between the client and the lawyer.
Okay, what determines when we use a non-legal consultant?
The district decides that.
Okay, so there's no problem in always wanting to talk to an attorney rather than this.
Oh, absolutely. No, we're not going to sign you up as a client and then turn you over to non-legal experts. No, that's not how we work.
Okay, so we could have a contract where this is exempted and not even addressed, or how do we handle it? If we don't want to go along with this, how do we handle that?
Well, you'd have to let us know whether or not that's a problem, and then I need to talk to my general counsel. What it would bar if we were to take that out is that we would not assign any ESS people to any of your matters, and we wouldn't be able to, provide those sort of services to the district. But it's not, the way we operate is we have a team that's assigned to assist the district. They're lawyers, and usually there's a primary contact. We want to make sure that the primary contact and the contacts at the school district end up getting along with one another, work well together, so that they have a trusting, attorney-client relationship. But we really let people select among the lawyers who they're most comfortable with, and we don't really have big egos over, who's representing particular clients, because, client contacts move around. But at the end of the day, right, while we work with client contacts like superintendents and assistant superintendents and the like, we work for the board, okay? And ultimately, it's the board who we work for, and we take our directions ultimately from the board.
Okay, we do advise seeking the advice of an independent attorney, so the idea of having to consult somebody before we sign on to you just kind of made me a little bit nervous.
Right, I mean, again, that's something which our general counsel puts in to make sure we're in full compliance with law. I'd have to speak to my general counsel if you would want to take that out and not have the ability to have ESS consultants available. I'm not sure that would be a problem, but, as with any sort of consent issue, the attorneys providing you with a contract have to advise you that you need to seek independent counsel if you have questions, because we can't advise you either way on issues of an independent counsel, right? The same would be true in a number of areas of law. You're doing, prenuptial agreements, right? The couple can't go to the same attorney and do a prenup and have the attorney advise both sides, right? Prenups always require informed consent and recommendation to, have it reviewed by independent legal counsel.
Okay, well, I just wanted to clear that up, and I'm just really nervous. Don't want to lose my attorney-client privilege.
You're not going to lose your attorney-client privilege because if you're working with an attorney and that attorney is advising you on legal matters, that is absolutely privileged, and that privilege can only be waived by the board.
Okay, thank you very much. Anybody else?
John, this may seem simplistic after all those other questions that you've been asked. How did you become aware that this contract was open?
Oh, I got a call
From?
from your acting superintendent.
All right, thank you very much.
Any other questions, trustees? John, before we finish, is there any questions that you have for the school board?
Well, I guess one question would be, given your current situation, how would you see our services being used, particularly, on an immediate basis?
If I may, I can't speak in terms of any of the happenings with the school board or some of the things that come out of this, but just on a day-to-day basis, we are kind of stalled in a lot of the issues that we're dealing with in our HR department. We just have ongoing things that have been problematic because we can't reach out to legal counsel, we can't take the step forward. There's some investigations, there's always ongoing things, complaints that we have to investigate. And without legal counsel, we're moving along slowly, but we're afraid of some actions without having somebody advise us legally.
Right, well, and that makes a ton of sense. Labor and employment matters are pretty fluid, and complaints, my goodness, the complaint practice has just really exploded over the last 5 years or so. I would have thought during COVID, we would have seen some slowdown in that because, depending on where you were geographically, some school districts completely went remote and shut down. In North State, not so much, right? Pretty much in North State, many districts were back pretty quickly. But the interesting thing is, really, the investigation practice didn't slow down at all. Our investigators were busy all throughout the pandemic and remain busy now, but that is certainly things which are in our wheelhouse. Labor and employment and investigations are something which we could provide immediate assistance on.
Any more questions for me, John? John, can you still hear me?
Yes, I'm here.
Do you have any other questions for the board?
No, not really. I thank the board for the opportunity to interview today, and if we're selected, we look forward to working with you in the near future.
Well, thank you for the trouble you've gone to just accommodate our schedule here today.
Well, no, it's my pleasure.
Okay, thank you.
All right, thank you. See you later. Have a good meeting.
Just a note, some of you are talking while this is on and it's keeping us from hearing everything that you're saying, so try to keep the conversation down while we're talking to these people. I appreciate it. Thank you.
Also, for anyone standing, there's a few seats on the front rows up here. There's one here. I don't know if anyone's interested, but There are some seats. There's one over there as well.
Regardless, somebody wants to sit from now on.
Okay, next candidate is Mrs. Lindsay Moore from Kingsley Bogart. Lindsay, my name is Steve Henson. I am the interim superintendent, and I'm going to have the board introduce themselves to the president.
Cheryl Clifford, present.
Nice to meet you. Lindsay Haynes, Vice President. Nice to meet you.
Elias Haynes, local board.
Nice to meet you.
Bill Wallace,
Nice to meet you.
Bill Lewis, and your name is Lindsay?
Lindsay, yes.
Thank you very much.
You're welcome.
I think the mic on, Nathan?
It is, okay.
So it's in the best and fair hiring practice to ask all the candidates the same questions. There might be some follow-up questions that will be asked by individual trustees based on candidates' answers. So just briefly, can you just tell your personal background?
Absolutely, yes. I've been practicing in the education law realm for probably about 16 years. I started out initially actually in the DA's office as a prosecutor in Walnut Creek, so Martinez area, Contra Costa County, and have been practicing, however, in education law since about 2007 and have been with Kingsley Bogart now for about 10 years of that time.
Okay.
Practicing most primarily since in the ed law area with school districts specifically, our firm represents primarily almost 99% of our clients are all public agencies, and the vast majority of those clients are school districts.
So I have a list of questions. You might even touch on some of the answers
Okay.
to one of them. But anyway, we'll just go through them. If you need me to repeat it or clarify it, feel free. So does your firm currently contract with school districts, or have you in the past?
We do. We represent throughout the state of California probably roughly 30 school districts or 30 school districts and county offices of education. We represent both.
Okay. I'll be turning to the trustees. Just stop me if you have a follow-up question for any of these. Can you please provide a synopsis of your firm?
Sure. Our firm, Kingsley Bogart, started out as Pinnell and Kingsley about 25 years ago with the founding partners. Mr. Kingsley retired about 5 or 6 years ago. We are Kingsley Bogart. There are 3 partners in the firm. We are smaller. We have 3 associates as well, and we're looking to be recruiting to add more. But we're a smaller firm, and we pride ourselves on the personal service that we can provide. Because of our size, when somebody from the school district picks up the phone, they know who they're going to be talking to, because you will get to know each and every one of us.
So how many collective bargaining agreements with school district unions have you negotiated? Of those, how many have gone into impasse and or PERB, and what was the outcome?
Forgive me, don't hold me to exact numbers. I'm trying to think of collective bargaining agreements. There's been two to three school districts that I have actually had the unusual experience of starting from ground zero, meaning the union comes on board and we actually have to start from the very beginning to create a collective bargaining agreement, which is a very different experience than what you usually have, right? Where you actually have an existing contract and you're looking and selecting specific articles that there's an interest in, right? Whether it be the district or the employees, the certificated or classified site. So probably, I'm going to give you estimates, probably about 20 to 30 different contracts. Now, I'm not the only one in the office that handles labor negotiations. Kim Bogart does as well. But for myself, probably about 20 to 30 different rounds of negotiations throughout the years. Impasse, we've had a number of times where impasse has been declared at the table. A couple of times where the district agrees, so I'm representing the district, we agree with that. Other times where we disagree and PERB hasn't actually certified for impasse because they believe there's more work to be done at the table. We used to be able to say that we had been all the way through the impasse fact-finding and strike process, but about 5 years ago we did find ourselves there representing the school district, and it's nowhere that anybody wants to be. The board, the employees, it's very detrimental, but sometimes that's where you end up.
So what experience have you had dealing with union grievances and employee discipline issues?
Quite a bit. I'm not gonna give numbers because I don't think I could even estimate correctly. But I would say with probably 20 to 30 grievances a year, give or take. Whether or not it stops at the first informal level or makes it through multiple levels, or maybe even we do have a couple of matters going right now that have made it all the way to the grievance process and binding arbitration as well. It's fairly common to see those grievances come through. Fortunately, most of the time you're able to resolve them before you actually have to get to arbitration through that process. With regards to employee discipline, also quite a few of them. I have not gone to hearing very often, but I have had to go to hearing. Many of them also resolve prior to getting to that place. But we have been there, I have been there, and walked the district through that process. Starting from the very beginning, the investigation itself, then to the drafting of the actual charging document for the dismissal, and all the way through the dismissal process.
Thank you. How many uniform complaints and Title IX complaints have you investigated, and what is your process to ensure that you and the district meet the timelines associated with these complaints?
Okay. The first important part is to, when you receive the complaint, determine what kind of complaint it is, right? Just because it is labeled as a uniform complaint does not necessarily mean that's actually what it is. Oftentimes in the board policies, it will actually state at the outset that the district assesses and determines the appropriate complaint procedure. It's really important to make that assessment and make that assessment right away so that you can know what those timelines and deadlines are, right? The Title IX process, which has been fairly recently in the last 3 to 4 years, updated and revised and has a lot more timelines in it than it used to. Uniform complaints also have a hard 60-day time frame unless you get consent from both parties. So it's very important to assess the complaint when it immediately comes in and make sure you identify what those deadlines are so that you can work together as a team with the district to meet those requirements. And be sure that you know what each and every one of those steps is, right? Because the policies might be slightly different from district to district. There's going to be notification requirements and timelines that have to be met.
What is your experience in interpreting ed code in support of district requirements and needs?
Was the last word needs?
Needs, yes.
Okay. Well, there's a case out there from years ago, and they say the education code's like a bowl of spaghetti. And it used to be one book, and now it's 2 big books. It keeps getting added to year after year. I mean, that is a lot of what we have to do as attorneys, right? And oftentimes by the time it gets to us or the need to actually call our office is because there isn't a clear-cut answer, right? And you're actually going to have to look to neighboring statutes or surrounding statutes to find out what the intent was behind the statute itself, sometimes looking at legislative history. But we have to do that on almost a daily basis to make sure that if an issue comes up, whether it's student discipline or employee discipline or leaves, for instance, leaves is heavily driven by statute, to make sure that you have a good understanding of what exactly is required of the district and what you have to comply with.
Aside from the legal research databases, what resources do you have readily available should you be tasked with an area of law that you are unfamiliar with?
Well, I mean, you're right, we always have the legal databases. We also have, attorneys with a lot of experience in our office and experience in different areas. So, we are a small office, we always have our doors open, we're always there to assist each other, right? To make sure that we gather the information and knowledge that we have to be able to answer those questions. If one of us hasn't handled it, chances are somebody else has. And because we've been in practice for over 25 years, that also means that we have records and databases and previous research on hand to go back and refer to as well.
Gateway currently has 244 active employees and approximately 2,200 student enrollment. Frequently, we have had multiple student, employee, or public issues arising on any given day. How will you prioritize dealing with the issues, and what will you do when you have multiple issues that require immediate attention?
We have to navigate this. I think everybody probably does in their daily lives and their jobs too, right? We need to gather all the information and find out what all the issues are, and to the extent that there's numerous ones, determine which one the most pressing one is that needs to be handled most immediately, right? To the extent that there's immediate issues that have to be addressed now, and I on my own can't do it, that's where I would utilize the assistance from other attorneys in my office to step in and provide that assistance. But I am always accessible. That is something that we pride ourselves on as well. With my cell phone text message, right? If I'm in a meeting, I can respond back and let you know, but we are here to help, right? We're here to be a part of the team, whether that means a phone call at midnight, which has happened, right? During a board meeting and somebody has a question and we pick up the phone and we answer it. We're here to be a part of your team and help you. So sometimes that is prioritizing what needs immediate attention.
So what experience do you have regarding employee leaves, Ed Code, FIMLA, CFRA, in conjunction with bargaining units agreements?
Okay. Actually, ironically, partner and I, Kim Bogart and I were just presenting on leaves at a conference in Southern California last week. So we do quite a bit of that. We have a leaves handbook that we prepare and we provide to our clients. We're here to answer questions. It's a difficult area, and there's going to be distinctions, right, between the law and the collective bargaining agreement might be a little different than what the law requires, but you always have to know what the law requires. We can't do less than that. The collective bargaining agreement can provide more if that was the will of the district and that's what's in the agreement, but we always have to make sure that we're complying with the mandates of the law.
How does your firm support school districts in remaining informed with the changes in the law?
A couple of different ways. When big changes come up, we'll do client alerts and send them out to the staff members that we work directly with most often. So oftentimes that's assistant superintendents, superintendents, or directors, right? So we'll provide client alerts. If it's something specific that we know directly impacts something that's happening at the district, one of us would reach out to one of the contacts we have to make sure that you have the information you need and understand it. An example of that was Juneteenth and the changes to the law, and we had pending grievances. Rather than just send the notification out to clients, those of us that had pending grievances picked up the phone and talked to those clients and said, you know, the law has come out, the law says this is what we have to do moving forward.
What experience do you have in dealing with the maintenance and operations side of a school district when looking at the following: public bidding contracts and the regulations set forth regarding them, CUBCA, accounting practices, labor law related to classified staff, state and federal law related to district facilities, and required practices, procedures to be followed?
That's a loaded question. A very broad question, actually. So first, starting out probably on the facility side, if I want to call it that, right? So you're looking at bidding and CUBCA and other requirements that have to be met if you have a construction project, right? And you're looking for contractors. Is this something we have to comply with the bidding requirements? Have we adopted the CUBCA resolution that might give you some alternative options, right? Rather than going from beginning to end all the way through the competitive bidding process. But at the end of the day, the end goal for those processes for construction is to make sure that you, the district, are finding a good contractor, but a contractor who's going to have the most relevant experience, but also oftentimes the lowest bidder in that process too, so that you make sure that you have competitiveness amongst the contractors to make sure that you are spending the money wisely of the district. So for construction, that's background experience. We've done RFPs, RFQs, right, depending upon whether or not you have to go through a formal process or an informal process. There's a lot of different, construction contracts. There's independent contracts that you might need for smaller projects or something that you're bringing somebody on board. Knowing what the bid thresholds are, when do we need to go to bid versus when do we not need to go to bid. So I have experience in that area. Construction also inevitably, sadly, doesn't usually go smoothly. We probably know that in our personal lives as well. But also have wound up in litigation having to challenge a contractor through the process to make sure that what you contracted for is actually what you get, because sometimes that doesn't happen. I know I've missed a few things. I think you asked about classified employees. So to the extent that you were asking about negotiations and collective bargaining agreements, the numbers I was giving you was for both classified and certificated combined. So I have a lot of experience. Our firm has a lot of experience in that area for both classified and certificated employees.
Gateway has the largest bus area in Shasta County, and our transportation department is crucial to getting students to our schools on a daily basis. What experience do you have in dealing with the transportation side of the school district and the required state and federal laws binding them?
I'm just trying to think back to some relevant experience or instances where this has come up. I mean, most recently for busing, for me, it's actually districts having to get creative because there's a significant shortage of bus drivers right now. So school districts trying to find out, what do we do? How do we do this? We need to get our kids to school. So some of my most recent conversations with clients have actually been, okay, how can we get creative? What can we do to get kiddos to school? I have another district that we work with that actually contracts with a private company that provides that transportation, which of course then you need to make sure the contract and what their expertise and the people that are driving the buses meet all of those legal requirements, because we also know bus drivers have to have specific licenses, they have to have specific training, and CHP is going to be overseeing and overlooking a lot of that.
Are you aware of, or do you foresee any conflict of interest in representing Gateway Unified School District?
I do not. We currently do not represent any other clients in Shasta County. We do have other clients in the Red Bluff area, in Butte County, but we do not have clients up in Shasta County.
So at this time, I'd like to turn it over to any trustees if you have any specific questions for Lindsay in regards to the contract that she submitted.
I want to ask you two things. One, how much do you use non-legal consultants, if at all? Like, for instance, when we call you, it sounds as though we're going to get you. That's
right.
a big plus.
Yeah.
So you're not expecting us to depend upon non-legal consultants?
No, and I'll give you, rarely would we be looking for that. The only time that ever becomes an occurrence is if a client asks for that specifically. I'll give you an example. I have a school facilities consultant, and we needed an expert in that area because it's a school district that's subject to significant development that's coming. So we needed somebody with state funding experience, which I will admit when I don't have it, right? I'm not the expert on state funding. There's people out there that are, right? So, but that happens at the request of the district. The other time that we have utilized a consultant, I think that probably meets what you're characterizing, is if there's a dire or a specific need for public relations. We do have somebody that provides that assistance for us in our office, but again, the vast majority of the time we do it ourselves.
Okay.
And it's only upon
Well,
request by
that's
the district.
encouraging, because in one of the other contracts, we were told that, that we wouldn't retain attorney-client privilege if, on basis. The other question is, what do you think is that makes you the best candidate of the three that we're listening to? Why are you the best guy?
Well, and I'm not going to, I and my firm, right? I am a partner with Kingsley Bogard. There's two other partners, and then we have other staff there as well. And we pride ourselves, I pride myself on being the small firm that we are, because our size permits us to have a really good working relationship with the school district. We really try to be a part of the team, right? We're here to help. Ultimately, we represent the school board as a whole, right? But we are on a daily basis working with staff, superintendents, assistant superintendents, and we like to find out, okay, what are the needs? What's the goal? And let's see if we can get there, right? But we're here to help through the process and be accessible so that if there is an urgent need, we can be there to help.
Thank you. Thank you very much. Sounds great.
Any other questions for the trustees?
Yeah, Lindsay, I previously asked the interviewee, how did you become aware of this contract, that it was open?
Sure. Someone from Gateway contacted our office. They didn't directly contact me. It was the contact who's on our website. I believe it was Beth Roberts that reached out to somebody at our office and asked if we were accepting new clients, and if so, if we would submit our contract for consideration.
Thank you very much.
Welcome.
Any other questions, trustees?
That's it for me.
So at this time, do you have any questions for us?
Well, I want to thank you for your time. I appreciate the opportunity to be here and answer the questions. I hope that we end up being the perfect partner for you as a school district now and into the future. If you had any, specific urgent needs, I suppose, we're here to help. And if that were the case, we'd be ready to jump in right away, but I don't have any specific questions.
Thank you. Appreciate you coming.
Okay, we're gonna have to declare a recess until we are able to connect with our next candidate. So we're able to connect to the next candidate.
I would say because
She was scheduled at 2, she's in court, she can't get away as quickly as she planned, but she still intends to talk to us. So it's out of her control, right? Okay, so we'll recess.
I am.
Call to order again, we have made contact with the next candidate, and we'll proceed with that. Steve?
Can you folks hear me?
Yes, we can.
Can't see you.
You can't see me. Yeah, I'm sorry. I have to get in a car and be transported. I sincerely apologize, but I have to do this on my phone. So my apologies for making you wait as well. Of course, I was the last case called.
Well, thank you for all the trouble that you're going to. We wish we could see you, but we'll have to proceed this way, I guess, for the time being. Unless you have some way of making it so that we can see you.
Yeah, unfortunately, I can jump on for a moment if you'd like to see me.
Please don't do anything that is going to put you in danger.
Yeah, and take your time.
Give me 1 second. I'm going to leave and then I can do this for a bit.
Break down the fees and stuff. Yeah, this stuff, actually. Missing it. I know I saw it.
Yeah.
Those are all printed out. That's not.
Hi folks, can you see me?
Fantastic. Yes, we can see you.
Okay.
Okay, we'll begin. I know your time is valuable as well.
And you can see us.
So you folks, I have a few minutes and I do have to get on the phone.
Okay.
So how would you, now that you can see me, would it be okay if I jump back on my phone, or would that be too much trouble? I apologize.
I
If
prefer
you really
that.
want to know what's going on, I'll tell you, but I don't want to make a big deal out of this.
I prefer how we're doing it right now.
Okay, I'll give you 5 minutes. Thank you. Okay.
Okay, so my name's Steve Henson. I'm the interim superintendent. I'm going to have the board trustees introduce themselves, starting with the president.
Yes, President Cheryl Clifford.
Lindsay Haynes, Vice President.
Lance Haynes, clerk of the board.
Dale Wallace, trustee.
Phil Lewis, trustee.
So it is best practices, fair practices, and hiring practices to ask all the candidates the same questions. There may be some follow-up questions after the individual candidate, in your case you, answers some of the questions. The board might have a follow-up question to that particular answer to the question. So can you just briefly just tell us a little bit about your experience, your background? We'll be asking about a synopsis a little later, but some of the other attorneys shared how long they've been an attorney, et cetera.
Happy to share. So I passed the bar in 2007, so that's, somebody do the math for me, 15 years. I've been a licensed California attorney. Prior to that, I was a litigation paralegal for a 40-year civil litigator. since 2002. My previous career was in marketing communications consulting. Prepared me for being a lawyer. In my practice, I've primarily been litigation, criminal and civil litigation on the federal and state level. I was for 6 months a public defender, which made me see legs in court. I don't know if any of you folks know public defenders, but they're in court every single day. And then since I had practiced with 40-year civil litigator who allowed me to sit second chair in litigation and do everything attorneys do except document and sign documents, I hung a shingle, and that's what led me into my own private practice. For a brief period of about 6 years, I was working for a firm in Novato area, and then came back to practice, private practice. My primary areas of focus now are civil rights, education, employment, and business. So people describe me as a creative problem solver. Within the bounds of the law, I can solve a problem. For your purposes, the more specific experience that would interest you is over the past 2.5 years since the COVID pandemic hit, I've been representing school board members, superintendents, teachers, and parents with all of the really challenging issues that they face. And what I find really interesting is opposite me are a lot of these big law firms like Lozano Smith, AALR, and I found some of their legal reasoning to be lacking, if you will. And I found that some of the advice that they've been giving their clients, and I know this because I was opposite of them in many of these cases, to be putting these school boards, superintendents, everybody at risk for liability. So this is why I'm here. I'm really excited to be invited to apply, but I think we need to change the situation in California and give school boards better advice. I hope that's a good summary. That's what you're looking for.
Yeah, it actually might answer a couple of questions coming, but you can address that when we get there. So does your private practice currently contract with school districts, or have you in the past?
Yes. Yes.
Okay. And I'll be turning to the trustees in case they need you want a follow-up question, so that's why you're going to see me nod to the left and see.
I'd like to know how many districts you represent and where they're located.
Okay, so over in Capistrano area, actually on that particular situation I represent a school board member. In the situation there was Brown Act violations. The district attorney got involved and we watched that situation. Over in, I'm thinking of the names, I can't think of the district, but school board member over closer in Northern California, actually 2 over there. Curry County, Clovis Unified Faculty Senate. That's what I can think of off the top of my head.
Okay. I think you addressed some of this, but in case you want to add anything else, please provide a synopsis of your, well, I have it firm, but of your practice. Yeah.
You kind of already did that.
I'm sorry, could you repeat that?
You kind of already did that. Can we go on to the next question?
Okay. So,
Just to be clear, there's a difference between trial attorneys and attorneys that work for corporations. I think that's the best way to summarize it. I'm in court.
sure.
The clarity I would have is, how many attorneys are in your firm?
Currently, I'm a sole practitioner.
Thank you.
How many collective bargaining agreements with school district unions have you negotiated? Of those, how many have gone to impasse and or PERB, and what was the outcome?
I have not done collective bargaining negotiations. I am partnering with several, sorry guys, that's my teenager being difficult. Several lawyers that are working on that. I'm actually being the Clovis Unified Faculty Senate, I'm working with them to develop their own bargaining unit. So this will be my first foray in that.
Okay. What experience have you had dealing with union grievances and employee discipline issues?
Well, over the last 2.5 years, that's what I did for teachers. and parents and school board members and superintendents is deal with the grievance issues.
How many uniform complaints and Title IX complaints have you investigated? And what is your process to ensure that you and the district meet the timelines associated with these complaints?
So are you talking about CDE complaints, government code section 910 complaints? Are you talking, when you say uniform complaints?
Yeah,
Like,
the uniform complaints that typically come within a school district will get a uniform complaint. We have to follow through and investigate that. Somebody will file that uniform complaint. And then Title IX, yeah, go ahead.
so my apologies. Go ahead.
No, but Title IX, federal, Title IX, can be complaints against if we're not following the Title IX requirements in the school district.
So you're asking how I would ensure that doesn't happen?
Just basically, have you investigated any of those, and how would you ensure that the district meets the timelines, because there's timelines that go with those complaints?
Well, we would have to meet and prepare to deal with those complaints, conduct the investigation based on the statute and the deadlines given. I think I understand your question. Generally, within an attorney's office, there's a calendaring system, and the statutes drive those deadlines. I personally have not, and in courts and those rules drive the deadlines, but I have personally not investigated those. Those would usually be sent out to an investigator to handle that, and I would do the legal reasoning and analysis and guide the people doing the investigations. And I have to confess that I am more on the other side, I have more experience on the other side of it, holding school districts accountable, if you will, holding superintendents accountable, than dealing with that particular thing. But in the scope of other types of complaints that come against school districts, I'm very well versed, especially in the last 2 years.
Okay, thank
Hope
you.
that answers your question. I think I'm understanding your question.
Thank you. Okay. What is your experience in interpreting Ed code in support of district requirements and needs?
Well, that's exactly what I've been doing for the last 2.5 years since the pandemic hit. I can give you one great example. So one of the clients I represented was a young girl in Placer area, and the school board had created a exclusion policy, thinking that some of the government guidelines could affect them. And used, I forget if it's the notice statute in the Ed code, but there is no such ability for a school district to create an exclusion policy. So the advisement, we went to hearing. The advisement was under Education Code Section 48900, the only way that you can refuse in-person instruction, suspend or expel, if he has to leave, he has to leave. But I have to finish. I apologize, you guys. Ainsley, I thank you very much, honey. Under Education Code 48900, the school district can only suspend or expel a student for clear and present danger. And the statute enumerates those very specific instances. Drugs, guns, bullying, that kind of thing. And there's a misconception out there in the educational world on the school board, school district level, that there is still an ability for disobedience or defiance of the child that qualifies as allowing you to suspend or expel the child. And I think it was in 2016, years ago, those statutes were changed because they were disproportionately applied. And that is no longer a standard. So that was a very repetitive situation where I was advising school boards, superintendents, parents, teachers that they could not exclude children unless they met those statutory requirements.
Okay.
It's one example of many.
So aside from the legal research databases, what resources do you have readily available should you be tasked with an area of law that you are unfamiliar with?
So that is what we do as civil litigators. We are generalists. So I'm not a workers' comp attorney. I'm not a family law attorney. I'm not a DMV hearing attorney, I'm a general civil litigator. So my job since I passed the bar, actually since 2002, was to take a legal issue and go figure out the solution. So that's what we do as lawyers, is we research. So in my particular practice, it's LexisNexis. It's all of the forms of pleading and practice. It's all of the treatises like that come along with them. So I don't know the answer to a question. I go to research to figure it out, and I gather up the tools that I need.
Okay.
Makes any sense to non-lawyers?
So Gateway currently has 244 active employees and approximately 2,200 student enrollment. Frequently, we have multiple student, employee, or public issues arising on any given day. How will you prioritize dealing with the issues, and what will you do when you have multiple issues that require immediate attention?
So 244 employees, I'm hoping there's not 244 issues at one time. I think that would require hiring another staff member, to be frank with you. But as I do in my life, current life as a litigator, there are structures that prioritize it for me. For example, answer to the court first. If a Douglas clerk calls, I stop what I'm doing. The other priority maker, if you will, is statute of limitations, right? So it would be a similar situation. My husband is a 22-year Harvard-educated Marine, and he was a principal, and he now works for a company called Curriculum Associates. And so I'm somewhat familiar with how busy schools are. So whatever the fire of the day is, if you will, based on a priority set by you as the board or set by the superintendent, that would be the first place I go. And then the rest of the priorities would fall into place under that. Deadlines drive priorities. If we have a child in harm in any way, priorities, that kind of thing.
Okay. What experience do you have regarding employee leaves, Ed Code, FIMLA, CFRA, in conjunction with bargaining unit agreements?
So I have primarily employee experience. My employer clients are mainly business issues. So I have a great deal of experience in that area since the beginning of my practice. I can tell you that recently, most of my employee clients, the employers, you have an issue, you make a demand to resolve it short of litigation, and if it doesn't resolve, you go to litigation. Most of my employee clients resolve short of litigation. So my experience has been very successful. I've actually unfortunately had to sue 2 employers recently. So everything from employment issues, termination issues, collective bargaining negotiations between employer and employee, all of it. Everything. There's all of it. I can't think of a particular example. I'm trying to think of a particular example to tell you, but most of my cases resolve in negotiation stage.
Okay. How does your practice support school districts in remaining informed with the changes in the law?
How does my practice support school districts? I'm sorry, I missed that part.
How does your practice support school districts in remaining informed with changes in the law? As the law changes, school districts need to kind of know what's going on. So how do you support the school district in informing them of the different changes in the law?
My practice is actually to let the client decide how they would like to be communicated to. Some people like to jump on Zoom meetings and have a conversation with the lawyer so they can interactively ask questions about an issue. Some prefer just to get a memorandum that they can read, the outline of the law. And, some just want regular updates, standard updates. So that's how I determine how to communicate. So it would really be up to you folks. But regularly, I write legal memorandum issues. Like recently, for example, in Reading, the board out there drafted and implemented a policy that misinterpreted the new gender identity discrimination law. So I took a look at the board policy, I did a legal analysis, and I wrote a communique to the attorney, which is a letter, informing them of the misinformation that they were providing to their board and the potential liability that would create. So like that's one form. It was sort of a way, a cease and desist, if you will, but it was really an analysis of the issue. And the particular issue was this new gender identity has been added to the law as a protected class, like race, religion. And the board, misinformed by a larger body in our state that deals with school boards a lot, I won't name names, to say that if an employee chose not to do certain conduct, they would be terminated or written up for not doing certain conduct in relation to gender identity. That's just not the law. And actually, the advice that was given in that board policy was putting that school district at legal risk for being sued by the employees for religious and personal freedoms. So again, to summarize that, it really decides how the finals to be communicated. So I do know that in this district you have trainings that are requested. I'm not sure if it's by this district or by your county. That's something that I do regularly. I call them legal Zooms, but you can call them something different. And again, I do regular memorandums, I do regular updates, and then I answer personal questions if necessary.
Okay.
Perhaps on the category of things that you were mentioning, where there's a gubernatorial mandate that says we have to do certain things, do we not have a constitutional right to refuse to go along with it if we deem it harmful to our local district?
So the school board is the smallest unit of democracy in our society. You folks have a lot more power than you realize. The limitation on that power is within the education realm. The legislature has delegated to you authority to do programs and services that you deem fit for your community, which is your schools, but within the education realm. And contrasting that, the legislature has delegated authority to health officers, right, to deal with health emergencies, and that's their realm, their police power by statute. So, if you want to try a particular issue as to whether or not you don't constitutionally have to comply, if you will, I'd be happy to have that specific conversation with you. But you do have, generally speaking, you do have a lot of broad power. You're the smallest unit of democracy.
Well, what I'm hearing is that some people feel that they didn't call it being terminated, but they had them leave. They're very positive that the reason was they refused to go along with the mask mandates or that they wouldn't get the COVID vaccination, and other terminology was used against them that made it sound as though it had nothing to do with their refusal to take the vaccine. Would you come to the defense of people like that?
So I'm understanding, so is it an employee or a student or a school board member that
Anybody,
not
like a superintendent, or for instance, if he decided that I don't think they should be forced to do something, would he have the right to do it? Would the board have the right to say, no, we're not going to force people to take the vaccination?
Well, getting very specific, the vaccination is not, the COVID injection is not FDA approved. Comorbidity was a brand that was approved, and they're not manufacturing. So starting with the basic fact that there is no FDA approved COVID injection. What that means is under federal and state law, it's defined as experimental, okay? When something is experimental, and this goes back to long time ago in our history, it requires the right to informed consent. So by federal and state statutes, you meaning anybody, cannot force somebody else to enter into a medical trial. And in the case of children, there's federal law that says it's illegal to enter children into medical trials without benefit. So if you're talking about the vaccine, none of these mandates are legal.
Okay.
And that is a place that a school board that if I was hired as your counsel, I would recommend you stay away from that. that belongs in the doctor's office, that belongs with the legislature, which recently the CDPH and new Senate decided they're taking that off the legislative table. There's no bills going through the legislature that are adding any more vaccines to the schedule. And so this is a place that you don't really need to go. Now, if you're talking about it from employer-employee situation, I do not recommend that you get into that.
Okay, but from the board's point of view, what our duties are, we do have a constitutional right to say we're not gonna enforce this mandate.
I thought this was an interview. Well, I want to be very clear, there is no mandate. That's what I'm trying to, people think there's a vaccine mandate. There is no mandate.
Okay, all right.
They did not add the COVID injection to the schedule of required vaccines. There's you guys know, you folks know, there's this list of vaccines that are required to go to school. That injection is not on that list.
Okay.
So you have no authority to mandate it as an employer, as a school board, on your parents or students. Is that your question?
Well, some school boards said we gotta do this, they apologized to the people, said, sorry, we gotta do this, the governor says we have to do it. So I just wanted to ascertain if you agree with that, because there are some people who would be applying for this job that would really, they do believe the mandate is the same as law. So.
And my response is, there is no mandate. Again, it's an experimental drug, and people need to make informed choices for themselves. And you as a body, if you mandate it and something happened to them, you could be subjecting yourself to liability. That is a very personal decision that should not be mandated.
All right, thank you. Is there anybody else?
I think Steve still has some questions.
Yeah, moving on, we got a few more questions left. Excuse me. What experience do you have in dealing with the maintenance and operations side of the school district when looking at the following? Public bidding practices and the regulations set forth regarding them, CUPCA accounting practices, labor law related to classified staff, state and federal law related to district facilities, and required practices, procedures to be followed.
So I have experience with ed code, government code, labor code situations. For example, recently just filed suit on the 12940 unlawful practices having to do with privacy issues. That comes up a lot in litigation, but again, most of my employee clients, I'm successful in negotiating a resolution prior to litigation. That's my practice, is to avoid litigation if possible. Solve the problem short of litigation because it's expensive, it's stressful, and there are no guarantees. And it really often doesn't solve the true problem. In terms, again, of collective bargaining, I don't have personal experience doing that. Colleagues that I've worked with that do that specific task for me. But I am going into a situation here where we're developing a bargaining unit for Clovis. So I'll become very versed in that. And I think, did I miss part of your question or did I hit it all?
I think that's because it's one of those where we just give examples and then you just paraphrase your experience.
Yeah, and accounting practices, again, that is something I would rely on an expert with. Take the facts from the accounting, do the legal analysis, and solve the problem, if that makes sense. I don't have any expertise in accounting.
Yeah, okay. Gateway has the largest bus area in Shasta County, and our transportation department is crucial to getting students to our schools on a daily basis. What experience do you have in dealing with the transportation side of the school district and the required state and federal laws binding them?
I don't have any experience in that area. But again, as a general civil litigator, if I take on a case I've never tried before, I am very adept at learning the law and solving the problem. It's my job.
Are you aware of, or do you foresee any conflict of interest in representing Gateway Unified School District?
I researched the board members' names. I do not know any of you. So no, I do not know who all the employees are, but I have not represented an employee or parent in your school district.
Same question that was asked of the others. What is it that makes you the best candidate for this job?
I think I stated it in the beginning. I am very passionate about making sure that school boards, superintendents, school board members, teachers act in the best interest of children. That's the job you all ran to do, and I want to help you do that job to the best of your ability. And what I've seen over the last 2 years with some of the other law firms is school boards, school districts have been giving very poor advice and subjective them to liability, and I find myself on the side of suing the school districts because of it. So I think I'm the best for the job because I can see both sides of the situation and advise and help you solve the problems that you have because they come up without creating more liability and acting in the best interest of the children in the school district.
So the last question was if any trustees have specific questions for this attorney in regards to contract.
Yeah, I already asked mine.
A question that I've asked of the other applicants, how did you become aware that this position was open?
A community member called me, and honestly, I'm fired, I don't remember her name, I have her number. And she said that they're interested in having you apply. So then I was asked to send documents in. And I have to say, those documents, I was not aware that those would be made public. So I want to be very clear about my contract is negotiable, especially the financial terms of it.
Okay, that was my next question because the other applicants, there are no retaining fees and you are asking for $12,500 a month in a retaining fee, and I was curious why you felt the need to require that kind of payment.
Well, I think that's what's confusing about my contract. And again, I didn't expect it to be posted on the website without discussion. So my fee hourly rate is $400 an hour. The way I build my practice is if I do the work, I bill you for those hours per month. If you prefer a different arrangement that works better for your district, that's absolutely negotiable. So it was a little confusing that it's gonna be 12 to 21,000 a month. That's not accurate. If you're averaging 23 hours a month, say that's the number that's average, that's only $9,200 a month. So that's a miscommunication on my part that I wanted to make sure we clarify. Did that answer your question?
I believe so. There was one other thing that I was curious about that I didn't understand. In your contract, you, under your heading, let me get to the page here. Your contract says Tracy L. Henderson Esquire, attorney, and Liberty and Gateway Unified. If I understand that you are considering entering a contract with Gateway, but who's Liberty?
It's a typo. Attorneys have one contract and they change client name, so that's a typo. And again, I was not informed that this would be made public. I expected this to be a negotiating document. So my apologies for the
All right, thank you.
You're welcome.
Any other trustee questions? So Tracy, do you have any questions for the board?
I'm interested in what your timeline is, and if you have any for hiring. I'm also interested in if you're wanting 2 or 3 days a week on site, how this would work. And then I'm interested if you have any pending litigation.
So normally we wouldn't have an attorney on site unless that attorney was doing an investigation working with the HR department. Sometimes that happens. As far as litigation, that we are involved in some litigation, which I can't go into details obviously about at this point. There's some litigation that we are involved with. Sometimes we do have, we're contracted out with another firm with special ed. Their specialty is special ed, so we do work with them a little bit in some of those areas. But yeah, I'm trying to think if there's any other questions that I can answer on that. We do have a couple things that are pending that we have to investigate. Parent complaint issues and stuff that we've been waiting for legal counsel to help us with.
Okay. Yeah, and in my practice, I work very closely with the investigators. Yeah, I was okay. So in your timeline for when you're making your decision?
It's actually next on the agenda is.
Oh, right quick.
Yeah.
ASAP.
Okay, so you have any matters you need help with? Okay, that's what I wanted to know. Thank you. Okay. Those are all my questions. I think you folks seem like a great board. Heard good things about you, so I don't have any other questions.
Thank you for your interest. Appreciate it.
You're welcome.
I had a good weekend. Bye.
Have a great weekend, folks.
All right, this is the time for open comment, 20 minutes, 3 minutes per person.
Are we ready? Thank you, board. My name is Christian Gardner. I'm a licensed clinical social worker, taxpayer, resident of Shasta County for 50 years. I've had 2 children go through the districts. And I want you to know I support public education. In fact, I'm very, very concerned. In part because the job this board plays, in part, is to shape the future of our nation. And that's real clear. And part of my concern is this. There is an attack. There is an attack on equal rights for all, regardless of race, color, culture, religion, sexual orientation, right here in Shasta County and in America. The attack is imminent and concurrent. The future of empirical evidence-based science in America is under attack. The future of American history, based on the reality of empirical evidence and well-established fact, is under attack. The future of critical thinking, based on a reality of empirical evidence and fact, is under attack. In fact, the very future of public education is under attack by extremism, coming from the likes of Tracy Lee Henderson, who has been quoted in saying, "It's time to tear down the public education system and start over." Boy, okay. In fact, alt-right activists and politicians with extreme agendas have been attempting to radicalize and divide our communities and our nation by bringing their political, cultural agenda and war into the public school system. In fact, some schools seem to be following the alt-right agenda of a convicted criminal by the name of Steve Bannon and his plan of radicalizing communities and students. And I quote, his plan is very simple. It's by going through the school boards. That's what I see happening here today. But teaching established facts based on principles of evidence by recognizing and celebrating and teaching diversity, and by teaching that the sacred American wonder called equal rights, justice, opportunity for all, regardless of the race, color, or culture, or religion, or sexual orientation, is what's going to save our nation in supporting our teachers and our public schools. Ladies and gentlemen, you have a grave duty. Please adhere to the American dream and ideal. Thank you.
My name is Kate Colby. First, I want to thank Debbie and Steve and the board. You held a very sane board meeting today. It was a refreshing change. The agenda being posted with the associated documents improved the transparency of this process, and we thank you. Regarding your candidates, I think it's very clear that you have 2 large firms that can handle what our school district needs, and you have 1 sole attorney who can't. A question to the board members, especially in terms of Tracy Henderson, who also has California Parents United of California, or Parents Union. Are any of you members of that organization? Because I think it would be a conflict of interest to even entertain a vote if you are. I want to thank Adam Pressman of the Swanson Law Firm for their work to encourage the board majority to follow board policy and open meeting law. Please know that the board president and trustees were requested to rescind their decision to bypass board policy 2120 by calling a special meeting. No response was received, which resulted in the writ of mandate being filed with the Superior Court of California yesterday and presented to y'all today. Want to send condolences, please. This is from Leanne Westfall and the Gateway Citizens Committee to Michelle Demo Davis for her loss, and thank her for her commitment to Gateway. Thank you.
My name is Ed Mann. I practiced law in this county for 20 years. And I just want to make a couple comments, first of all, about the attorneys that you heard from. The guy that represented the 200-man law firm was fantastic, but you won't get that guy. In a 200-man law firm in a little district is way out here, you're going to get somebody down the ladder. The second small law firm, if you deal with them, they're very competent. You're probably going to get somebody that you're going to create a relationship with. It's going to be a long-term relationship, and I would recommend that. The third person that I don't know who asked her to apply. She obviously doesn't have any experience representing districts. She charges $400 an hour, and you're going to pay for her to get educated if you hire her. But more than that, you're going to pay more than that. And the reason I say that is because there's a thing called the Gravel Project that advertises itself as a nonprofit legal organization that exists to fight unethical government and employer mandates and protect the freedoms of Americans, especially children. As an organization, the Gravel Project directly challenges the proponents of woke culture, and it does so aggressively. It also says that the Gravel Project is peacefully fighting for civil liberties on behalf of victims suffering from the abuses of woke ideologies. This includes fighting COVID mandates, abuses, and radical ideals such as DET, which is diversity, equity, and inclusion, CRT, which is critical race theory, and gender affirmative care, and similar Marxist nonsense masquerading under the guise of equity and inclusion. So what does this have to do with Mrs. Henderson? It also says the Gravel Project has retained California attorney Tracy Henderson, president of California Parents United, to file civil claims against a number of senior school districts from Coronado to Natomas, and various trustees and employees of such entities regarding their civil rights violations and breaches of numerous state and federal laws. What does that mean for you? Well, first of all, it means that if she does that, she's going to be very busy on the other side of any issues that she's going to be representing this district. And as an attorney, I can tell you that if you're working both sides of the street, you're going to have that thrown right back in your face. I don't think that's what she's going to do. Your question asking what a board could do to refuse a state mandate, I think is revealing. I think that she would advise you that you could. And I think that would generate numerous additional lawsuits against this district. We're a tiny district. We're not like LA Unified. They can have a tiny percentage of their money going to defend these lawsuits. This little district has spent a huge percentage of its funds defending those lawsuits. You've already invited 3. If she comes in and if you hire cables and do what I think you're going to do, which is make a statement to contest the state, you're going to get sued by citizens and the state, and that's going to come out of the pockets of the kids. And that's where that money should go, to the kids. Let some other big district handle those issues if you think they're important, but not this district. Don't put us in this firing line.
Good afternoon, Board. Suzanne Barrymore, CSBA. I'm just here to hopefully help a little bit. Cheryl, I heard you ask questions about the non-legal consultants that were in 2 of those contracts. And so I just want to kind of take another stab at trying to illuminate that for you a little bit. That is a legal way of creating transparency within those 2 contracts, because as you probably are learning, as you are a school board member now, there are all manner of legal issues that you're going to be confronted with, and not even the most seasoned board members or superintendents can anticipate all of them. And so what these legal firms are attempting to do is provide a bank of resources which may be available to help you. And I think similar to what you're seeing, where right now you have a lot of issues that are kind of hanging in the balance right now while you attempt to get the legal help you need. That's all those legal firms are attempting to do, is to streamline that process so that there's help available there for you if you need it. And by putting that information in the contract, It allows you to be aware of the fact that those are resources that may be available to you, and in no way are they going to impede or conflict with your attorney-client privilege. So I hope that helps. It's a little bit like if you hire a contractor to do a job and they tell you, we're gonna build the house, but we may have to do some leaching and septic work out in the field, but we'll get to that if we need to. These are the list of subcontractors we might use. Similar process, that's all. Thanks.
I'm here again and I'm speaking because I've been asked to by a lot of people. I feel not much hope because the way that I see things have gone since the new board members have come on, I think you had a grand plan and I think everything's played out exactly how you wanted it to. And I think that when we were at the high school and you did your motions and then everyone was saying, stop, public hasn't spoken, well, you went ahead anyway. Well, that was convenient because then the next week you got to say, oh, never mind, we don't need those because we're gonna appoint this guy anyway. You've asked for public opinion and I think you sit and you watch the clock and wait for it to run up. You don't hear anything anyone's saying. You have a very extreme agenda. Everybody wants to know what you're here for. It is so clear now. You are still so angry about COVID and you're so angry about all the gender things coming down the pike. And this is the district that I don't know why you thought we were all sleeping, we didn't care. I don't know why you chose us. But like I said before, we do not need this extremism. We fought the board against the vaccination. We fought for kids. I stood and spoke. No one mandated that. People had to be tested. Some did it, some didn't. No one got in trouble. You have to let it go. Now this second person, the first and second, I agree. The first group, huge, we don't need that. That second lady that spoke, and I didn't have a chance to investigate everyone and do any research because as per usual, you do a board meeting 24 hours before when we all have lives. I did investigate this Henderson lady. She has her Parents United thing and she lists all these things you can try. And at the end, if all else fails, sue. So for her to sit there and say, oh, I try not to litigate. Plus she says, I'm in the courtroom all day long. She couldn't be here on time respecting us because she was in the courtroom. She has no one else working with her. You have got to, you have done what you wanted this whole time. It is appalling to me. If you vote for that, I don't even know what we're gonna do. You don't understand. I want a new car. I don't have the money. Okay, I'm not gonna go get one. You can't keep doing these things and spending money we do not have. We don't have it. And I've invited you to come to the schools and see who you represent. You don't do that either. I'm angry now. I'm angry, and a lot of people are. And people are afraid to speak up and they're at work, and I had to take today off again. Not okay. It's just not okay.
Sorry, I didn't think I was gonna make it, so here I am. So it's typed up and I usually don't do speeches, I usually go off the cuff, but choosing legal representation is crucial to the strength and success of our district. I'm hoping that during your interview process, you ask all firms present how they advise their school districts to proceed during COVID. 2 law firms have prior experience with this time in education, and 1 firm does not. AALRR and Kingsley Bogard both represented school districts that did not comply with COVID mandates. I know this was a time in our students' educational lives that is near and dear to your hearts, and you want to protect our students in the future in regards to overreach. With that said, you have 2 experienced law firms in which to choose from. As our elected board member sitting here today, do you know with 100% certainty that the firm you select today is 100% knowledgeable and well-versed to defend you and our district in accordance with the 32,572 pages of Ed Code put forth by the state? If the answer to that is no, then the firm you are thinking of for our district is not the best fit. Does the law firm that you are thinking of hiring know who to reach out for special education legal advice, or do they have the knowledge to handle special education legal matters? Does the law firm that you are wanting to hire know how to handle some serious personnel issues that our district has encountered in the past? A law firm that does not know the answer to these questions will only waste time and money in circumstances where we need experienced professionals handling these delicate and time-sensitive matters. Finally, one law firm does not have the legal counsel experience in regards to the scope of services that are to be provided to our district. Most importantly, to our 3 new board members is protection for yourselves along with our district in regard to the Brown Act violations and future litigation. In addition, Tracy Henderson's firm wants to charge the district an additional $160,000 for a job her firm is not prepared to handle on day 1. Over the course of 6 years, if you choose Ms. Henderson's firm, the district will be out an additional $1 million. Let that sink in, $1 million. That is money that we can't afford and money that will be taken out of the classroom for the students we serve. Tracy Henderson's firm cannot be the solution for our district. And I will say, I have spoken to Tracy. I know Tracy. I know where her heart is. However, we can't afford $1 million extra in addition to what the other firms are charging us. We can't do that.
Madam President, I want to clarify for everyone in the room that the reason I handed Mrs. Ellis a piece of paper is because she's a classroom teacher at Shasta Lake School, did not think she'd make the meeting, so she emailed the superintendent a public comment to read for her. And so because she came in, she read it for herself. We did not prepare that statement for her.
Seeing as this meeting is occurring during my contract hours, my public comment needed to be submitted to the superintendent's office to read. So I will actually leave that with you. Sorry.
Hello, my name is Matthew B. Davison. I am a care provider for developmentally disabled adults, and I'm on the autistic spectrum myself, so forgive me if I focus too much on something sometimes. I was born, I'm older than I look, I was born in the middle of the Eisenhower administration, so I consider myself an Eisenhower conservative. I came here to see how competently this board would handle the issues that appear to be in front of it right now. I want to correct one thing that your third interview stated. They said that the smallest unit of democracy was a school board. That's incorrect. It's the voter. I assume that the school board was voted into place to be competent. I consider this whole matter about competency. Watching the interviews, I saw 2 firms that appeared to be competent. If I wanted to use a metaphor, one of them is like a fairly efficient small TIE fighter squadron who might go in and get the job done. The other was a bigger fleet that maybe could bring a lot more resources to it, but I believe you have 2 choices that are very clear there. The third person was basically, I've trained a lot of people in different disciplines down through the years and other things besides what I do currently. That's a trainee. So you're going to take taxpayer and labor money. Your job is boring. I'm much happier cleaning out a colostomy bag than I would be doing your job. Because you're bureaucrats, you have to be, that's your job. You have to do boring things, make boring decisions. It's not spectacular, it's not defending Western civilization. You have to make decisions about your workers, your schools, your district, and you just have to do that. That's what you were elected to do. This is not about a flashy cause. And I saw 3 choices, 2 of which would be a competent decision, and 1 of which would not be. So it would be nice if I know that my tax money is being used competently and not incompetently. So that's all I got to say about my observations of what happened here today.
still time, because I could add one more thing, if I could add just one more thing. Anybody that wants to represent a school board and thinks that the proposal that they submitted is not a public document, it would not be shown to the public, doesn't understand the Brown Act.
And that concludes the open discussion. We're going to move on to B, 5B, discussion and/or action to approve agreement for professional legal counsel services.
So before you're able to vote on it, at some point we have to vote on that.
So we're going to take motions now. Do I hear a motion?
Can I ask Mr. Henson a question first? Steve, do you have a recommendation of one of these firms or practice?
Yes, I do, just simply because I've contacted people in different districts. Obviously, as you know, close to us in this whole area, that Lozano Smith basically represents most of the school districts in this area, and they have a consortium. That's one reason it was cheaper. Getting some information from Lozano Smith, most of the districts belong to consortium. Well, I checked in this area with different people that know these two firms, and I also checked with people I know in Napa that know these firms, and asked them to ask around. And basically, what came back on this is that the Atkinson, Adelson, they had some very competent lawyers that work there. But as it was already stated, you don't know who you're going to get in a firm like that, but they do have a lot of resources. And really, one of the names that came out by more than one person was actually Lindsay Moore. They talked about the competency of Kingsley Bogart and said, but if you can, make sure that she is your primary attorney within that. Nothing against the others, but the other two, but they said that she is most competent. And they've actually been in some issues against Lindsay Moore and said that she is very competent. So, so that would be my recommendation.
She took the time to come up too.
Yeah. Do I hear a motion?
Do you have anything? No. I would make a motion that we select the Kingsley Bogart firm. Recommendations from the audience tonight all seem to lead that way. It is a smaller firm. I think they would give us more one-on-one hands with things. Easier to get a hold of. She says, call at midnight. And there were attorneys say, call at midnight. Right, Ed? So that would be my motion.
I would second that motion.
Now we go to discussion.
Yeah, discuss. A public comment again.
Yeah, sorry.
So this is, just to point out that on any line item, it's open to public comment at some time before they take a vote. So if there's any more public comment before they take a vote on that, this is the time that you'd come forward and speak. Excuse me, respectful, please.
My name is Dolores Lucero. You heard 3 attorneys speak, and they gave you every question that the interim Steve questioned. I'm standing there and I told myself I wasn't going to say nothing. And just hearing you all say what you recommend, and it's not about what they want, it's what you think is best. You have the power who you should vote for. And even though Steve's recommending a certain person, a certain attorney, law firm, you don't have to vote on that. If you want Tracy Henderson, you think she's the best for this job, then vote on it. That's what you need to do. You don't have to follow the recommendation. All he's doing is recommending. So go for what you came in here to do, to vote somebody in who's going to represent the citizens. That's all I have to say.
So you're saying they colluded?
Excuse me. Respect, please.
Okay, Kobe, the board members, as I stated before, you have two very competent firms. The reason that you do listen to your recommendations from the folks that actually do the work in the school district is because they know what they're talking about. They know what you're up against. School board members, I admire you for doing your job. It's hard and it's humbling to recognize that you don't know their job. So please, accept the recommendation of your acting superintendent and vote the Kingsley Law Firm as legal counsel to protect this district so that our kids can get the best education and not waste money training someone who has no clue what it means to represent a district. Thank you.
So I didn't get to hear the first part, but I did watch some of the interviews. And I have a question. So the Henderson Law Firm, do they have a $12,500 minimum fee per month?
She said it was negotiable, so.
But the other ones have no minimum fee per month.
Correct.
So why would we hire someone who has a minimum fee when we are a school district and I can't even get pencils in my classroom? Where does this money come from? Do you guys have a special tree that is growing money in the back room somewhere? I don't know where you think money is coming from that is going to pay for your 2, 3, 4 superintendents, for your lawsuits that you're incurring. And you guys keep saying that there's no hidden agenda, that you came here to do what was best for the kids. But I'm gonna tell you, my crystal ball tells me that Henderson is gonna get the job today. And you're gonna tell me that there's no special agenda here, no hidden agenda, that you did not get elected with some agenda in mind, that you wanted to do what was best for the kids. I don't believe it. And I don't think anybody here believes it either.
Hey, how you guys doing? So, from my experience, and I heard all out there, the way you guys talk to these people, they're gonna pick against what you say. Like, you guys are putting them in a spot where they're not gonna give a shit about what you guys have to say. In my opinion, like, there's one of them run their mouths again. So here's my thing. In all honesty, the last lady, it was a joke. I wouldn't hire her. You show up late, you say you're driving, then magically you're at home with your teenage son telling him to wait. I mean, at some point we have to step back and pick what's best for the kids. And if you don't have the time to dedicate to an interview where you're gonna make $100,000+ a year, you're not the person that this district needs. This district, you talk to some of these teachers, talk to Karen Butler. In normal situations, she's a pretty decent lady. But she's speaking up here with passion and she's pissed off. Because in her district, or in her school, she has kids that go without lunches. She has kids whose parents won't fill out free lunch programs and they get an apple for lunch instead of a regular lunch. She has little girls in her classroom that go to school with an abscessed tooth for months because their parents live on the side of the lake. When the lake goes down, her enrollment goes up. Am I not correct, Karen?
Okay, let's just do this. First of all, no.
So once again,
No, you address me. So you wait.
It was a question.
You get the respect that I've been given as an educator.
Okay, so once again, I'll go on now. So when the lake goes down,
You do not know what's going on in my classroom, so you do not use my passion against me here.
No one's using it against you,
Karen,
guys.
please.
Look, realize that. Realize that.
Karen, thank you.
Realize that. So if Karen Butler let me talk, as the way Lakehead goes and the way Grand Oak School goes, when the lake level goes down, their enrollment goes up because kids are living alongside the lake. Somehow I'm wrong about that, I guess, Karen, but that's how it goes. Grand Oaks is based around the lake and Lakehead. Their enrollment goes down because a lot of the kids, when the lake comes up, their enrollment goes down. The kids live in campgrounds. So spending money and wasting money, it's not what's right for the kids in this district. That's what I was trying to say without you getting so hostile. Thank you.
Jesse, thank you for pointing that out.
So, good evening, board. I want to give you some clarification about the feeding in our district. My name's Sean Hayes.
Can you talk in the microphone? Thank you.
I'm the director of nutrition for the district. Gateway School District has universal feeding. Every child gets a free breakfast and a free lunch. I just wanted that known.
Thank you.
I think you're gonna make a good decision on this one. But I do have a concern because Gateway on the home, Mr. Henson, this is kind of for you too. On your homepage, you have 30 job listings, about 30 job listings. None of them are for the superintendent. I don't know who you're considering or who you've decided on for superintendent, but I don't know how you get applicants for superintendent when you don't even have it on your homepage.
First, I'll apologize for not having.
I just want to remind people to speak on this subject, that was not on the subject.
Well, the last speaker wasn't either, but I am a little crazy. I'm definitely crazy when it comes to kids. And if you're gonna talk statistics, we have about 12 kids who take the Lakehead bus after school, 12. We have 350 kids in our school. I am angry, I have a right to be angry. And we have been treated with disrespect by this board, and I have a right to be upset about that. So for you guys to keep saying decorum and you're so rude to them, you don't think it's rude? You don't think it's rude to ask us to come here and speak and tell you what we want, and then you just roll over us anyway? You don't think that that is an issue? It's an issue, and you don't expect passion about that? I am passionate. Don't bring my students into this. You don't know who my students are and my families. It's just a simple thing, like he said. This person isn't qualified. You have candidates who are. We have so many issues in the school besides COVID mandates and gender issues. All of that needs to be addressed. That person sues districts. She is a parent advocate who sues districts. Why would that be our choice?
Thank you. I'm going to leave 15 seconds. I've worked with a lot of clients that were in very, very bad shape. And it's really simple. When you're stuck in a hole, stop digging. Get a good lawyer.
Cheryl, one more. So obviously, hearing what's going on in the audience right now, I'd like you guys to get protection that can help you right now. And I don't think Tracy's that option. So you need the protection.
Madam President, there's a first and second motion that's on the floor. Now would be the time to ask any of the Board of Trustees if they have any comments on this, and then take a vote.
Any more comments by board members?
Yeah, I have a couple. There is one thing to lighten the load and to deepen the load just a little bit, because I don't want to adjourn without this being public knowledge. I was made aware that a long-term board member passed away Monday, Fred Braun. And I just want to give my condolences to his family, and he dedicated years of community service to the school district. That's off task. On task, I have felt a tremendous amount of frustration since January 13th. And I am not an attorney at all. And my frustration evolves out of the fact that our district can't get legitimate legal advice. I don't know the ins and outs of why our former legal representation left their positions that they did. But I am more than happy to try to move our district back into the protection of getting decent legal advice. Thank you.
I'd like to go along with Ed Mann and say that an attorney who sends something to a board doesn't know it's gonna be public record, doesn't really understand what the job is. Because she knows it's gotta be out for us to review, and it's gotta be in the public comment, or visible to all people that look at the agenda. So I still strongly recommend Kingsley Bogart.
Any more comments? Okay, the motion is to hire Kingsley Bogart, and it's been seconded. Shall we vote?
Sure.
Mr. Lewis?
Yes.
Mr. Wallace?
Yes.
Yes.
Mr. Haynes?
Yes.
Mrs. Haynes?
Yes.
Yes. The meeting is adjourned. Have a good weekend.